Welcome, everyone, to our third and final small business webinar for the fiscal year 2024 to 2025. Please stay tuned for next fiscal year's webinars in all of our usual spots. So my name is Margaret Lorenz, and I'm one of 5 staff attorneys at the Modest Means Helpline. My nickname is Mia, so if you hear that name uttered, that is me. Also with me is attorney Taylor Duffney, who is an attorney with the Briones Business Law Consulting Law Firm. The Briones Business Law Consulting Firm is based in Albuquerque and works with businesses throughout the state. The Briones Law Firm strives to be your corporate counsel so that your business is compliant, protected, and well advised. We are thankful to Attorney Duffney for lending her expertise to us today on this relatively complex topic. Also with me is attorney Casey Daniel, the managing attorney for the Modest Means Helpline and legal services director for the State Bar Foundation. Today, I'm going to be the moderator for this webinar. If you have questions, please type those in the question and answer box. I will periodically pause the presentation to ask your question. Also, if you have ideas for a future topic for these webinars, please put it in the question and answer box too. We're eager to do what you would like to have done. I must discuss a few administrative things, so please bear with me a few moments. This presentation provides you with general legal information for purposes of providing examples only. Neither the Modest Means Helpline nor any presenters are entering into any attorney-client relationship with any attendees or viewers of this webinar. We will not be discussing specific situations in this webinar, so please refrain when asking questions about anything too fact-specific. You can call the helpline with your specific questions after the webinar, and if you're eligible, we're able to go into detail at that time. Additionally, income tax requirements, tax duties, and tax responsibilities are beyond the scope of this webinar. When it comes to small businesses, there are always tax considerations, so be sure to get the advice of your trusted CPA or lawyer. The Modest Means Helpline is a civil legal telephone helpline and attorney referral service of the New Mexico State Bar Foundation. The Modest Means Helpline assists New Mexico residents with incomes below 500% of the federal poverty guidelines. The Modest Means Helpline can assist in civil legal matters, including but not limited to domestic relations, landlord-tenant, small business, contracts, consumer, and probate issues. This webinar is entitled Independent Contractor or Employee, How to Navigate Legal Classifications and Contracts. A common theme that you will hear throughout this webinar is, it depends. You may listen to this webinar and realize a distinct answer to a question you have regarding the differences between independent contractors and employees. And if so, that's terrific. But it seems to me that the more likely realization is that the distinction between the two types of workers is not always super clear or definitive. So the goal of this webinar is to expose you to the different tests, the laws, the rules, the different tests that different agencies have. Not so that you will become a master of these tests, but so that you will gain insight into the issue. So that if something comes up in your business, a light bulb goes off in your brain and you either dig deeper and get an answer for yourself, or you consult with a trusted professional for help. Failure to realize these red flags in this context can be costly to your business. Again, you did not go into business to become an expert in the legal distinctions between an independent contractor and an employee, but failure to realize an issue and get an answer could cost you your business. So here we go into the world of tests and rules. Do not despair if the weeds seem to get thick. At the end, the key takeaways will be highlighted for you. And so at this time, I am super excited to turn over the presentation to attorney Taylor Duffney. Take it away.
Thanks, Mia. So this table really kind of tells us why this distinction is important. So as most of you know, employees come with certain protections and responsibilities that don't always happen or come to the same extent with independent contractors. So this is just kind of a quick cheat sheet as to whether something applies to an employee and an independent contractor and in what context. So everything is going to apply to the employees. It's only going to apply to independent contractors in certain circumstances, but there are specific qualifications for some of these that come with how many employees you have. So workers' compensation insurance, that's only going to be if you have 3 or more employees. FMLA is going to be if you have 50 or more employees, and ADA is going to be 15 or more employees. Now, I will caveat the ADA piece really quickly. It's not the topic of this seminar, but ADA is 15 or more employees, but the New Mexico Human Rights Act applies to all employees working in New Mexico, and it has ADA type protections in it. So don't let that 15 plus throw you off. Next slide, please. So it's really important to understand that there are different tests for different agencies when we're talking about independent contractor versus employee. So unfortunately, that means that there is a scenario where under one agency and a worker is deemed an employee, and under a different agency test, the worker is deemed an independent contractor. It's unusual that something like that will happen because they do tend to follow a common theme of analysis, but they are different and they are distinctly different. And so there is a circumstance where that can happen. So there's not a one size fits all option here. And it really is important that you analyze the specific circumstances and are very careful with who you determine is an independent contractor, because there are significant consequences for misclassification under all of the various agencies. Next slide, please. So we're going to start with the Department of Labor and the New Mexico Labor Relations Division and OSHA. So they kind of follow the same test, and it's really going to be 6 factors that come into play here. The first is going to be the degree to which the employer controls how the work is done. And this really comes into an analysis of, does the employer, the company, and I will say employer, but that doesn't necessarily mean they're an employee. I just tend to say employer because it's easier than saying company or corporation or whatever the case may be. So don't let the word employer throw you off. But this first factor really is about the employer's power over the worker. So do they have the power to hire and fire the worker, supervise them, control the work schedule, the conditions of employment, determine the worker's rate and method of payment? Do they maintain employment records? How much control does the employer have over these types of matters is going to depend on the circumstances. The next factor is the worker's opportunity for profit and loss. So generally speaking, when we're talking about an independent contractor, they're in business for themselves. So their business decisions and their efficiency is going to have a significant impact on their profits and losses, where employees generally are paid the same amount regardless of how much they get done at one time. Now, of course, an employee's efficiency can affect whether or not they remain employed, but the actual work doesn't determine their opportunity for profits and losses. Now, that's not always the case because there are employees that receive commission, but this is a general framework. But when we're thinking about employees versus independent contractors, and independent contractors in business for themselves, so the more projects they take on, the more efficient they are, the business decisions that they're making of how do I allocate resources are all going to impact their ability for profits and losses, where an employee is not making those kind of decisions. The employee shows up, they do their work for however long they do their work and are scheduled to be there, and then they go home. The third factor is the amount of skill and initiative required for the work. So this one always tends to throw people off. But the skill and initiative factor comes into play because this helps determine whether the worker is acting in a business capacity as an independent contractor, and also whether or not they have specialized skills, and whether the use of those skills comes into play where they can leverage and those skills to perform the work. So, for example, a doctor. A doctor has specialized skills. A doctor has the ability to leverage those skills into finding certain circumstances and situations that work best. So, there are certainly employee doctors, but there's also a lot of independent contractor doctors where they're providing services for 2 weeks of the month for one business or one hospital, and then they're providing services for another hospital or another clinic for 1 week, and then they have a week off. That's really common in the field, and part of the reason they have the ability to do that is because they have this significant skill that they're able to leverage and kind of get themselves into various positions. At the same time, a worker's specialized skill does not prove an independent contractor status, especially if the worker doesn't use those skills in any independent way, such as by operating a business. So, again, it's not one factor that's going to determine whether or not an employee or a worker is an employee or an independent contractor. It's all going to come down to a totality of the circumstances analysis, which is something lawyers like to say. That means we're just looking at all the factors and we're weighting them similarly. There's not one factor that's going to say, okay, if this is true, they're definitely an independent contractor. If this is true, they're definitely an employee. The fourth factor is the degree of permanence of the working relationship. So an indefinite period of time is generally going to lend itself more to an employment relationship, where a set time, whether that be it's 4 weeks or whether it's until the project is complete, that's going to lend itself more to an independent contractor relationship. So, for example, think about the plumber who comes to fix the plumbing at your office. They come and they are working on site at your office, but only until the work that they were hired to do is complete. Whereas your employee at your law firm is coming and doing the work every day until one party decides that they no longer wish to be employed or to do the employing. The fifth factor is going to be the worker's investment in equipment or material required for the task. So again, employees generally show up and all the things that they need to do their job are already there for them, where an independent contractor invests in their own tools and equipment and materials, and again, they're running their own business. That is really the key distinction here, is things that lend themselves to running a business are going to lend themselves more to an independent contractor relationship. So, do you provide the computers or the tools or the materials to perform the work, or is that something the independent contractor is bringing with them? Now, keep in mind that simply an employee or a construction worker bringing their own tools onto the job site doesn't necessarily mean they are an independent contractor, but it is a factor that is weighed in the favor of an independent contractor. This also comes into an analysis of the economic investment that the parties have made into the project. Employees generally don't have a lot of economic investment in the business. They, again, come to work, they show up, they do their job, they leave and go home. They're not putting money into the business. They're not investing in tools. They're not investing in additional trainings. things like that. So it's if that's happening, it generally lends itself more to an independent contractor relationship. Employees generally receive reimbursement for business expenses, where independent contractors probably won't. An independent contractor is doing all of that on their own. And so that's why they don't have those same employment protections. They are in business for themselves. And then the last factor is the extent to which the services rendered is an integral part of the employer's business. So let's think of the example of my law firm hires a marketing firm to do the marketing for our law firm. That is an independent contractor relationship because the integral part of our law firm is the provision of legal services. But to be able to do that, we need to be able to get our name out there. We need to be able to reach a wide variety of clientele. And that's why we hired the marketing firm. But the marketing firm is not providing the services that our firm is providing. This one is generally one that trips a lot of employers up. Again, it's not a definitive, determinative factor, but it's a big one that generally doesn't weigh in the favor of the employer when this issue arises and there is a question as to whether there's an independent contractor relationship. If you are a nail salon and all of your workers are classified as independent contractors, but they're the nail techs, they're the ones providing the services that your business relies on to be able to make income, this is a factor that's going to weigh against an independent contractor relationship and could be a big issue. So I often hear from clients, well, it's standard in my industry. And the thing that always comes to my head when they say that is my mom, when I was 16 years old, and she used to say that cliche phrase to me of, well, if all your friends jumped off a bridge, does that mean you're going to jump off a bridge? Just because it's standard in your industry doesn't mean that it's correct. And you don't want to be the guinea pig. You don't want to be the business that gets reported to the DOL or the New Mexico Labor Relations Division, and all of a sudden it's your books, it's your employees, it's your workers that are being dug into because A, those investigations are really time consuming and they take a lot of time and effort for you. They can also be expensive, and the ultimate result could not be in your favor. So it's better to make sure you have the knowledge and have had this analysis done with a professional to make sure that you are doing what you need to do, because you don't want to be that guinea pig. You don't want to be the one jumping off the bridge just because everyone else is. Next slide, please. So the next couple of agency tests that I'm going to go through, you're going to see a common theme. They're going to have a lot of the same similar questions, I guess, for lack of a better term. There's just a different weight given to those categories and those factors. So for the IRS and New Mexico Taxation and Revenue Department, they're essentially using this analysis of control versus independence of the worker. So what they say is all information that provides evidence of the degree of control and independence must be considered. So unlike the DOL that has that 3 or 6 factor test, the IRS and Tax and Rev are essentially saying everything that pertains to the degree of control and independence is going to be taken into consideration, even if it doesn't fall into one of those specific 6 factors that we talked about earlier. So the 3 categories that the IRS and Tax and Rev really group this into are going to be behavioral, financial, and the type of relationship. So behavioral, we're going to talk about, does the employer have the control over what the employer or worker does and how the worker does it. So this isn't to say that you can't have any control over what's happening with an independent contractor. Let's think about that marketing example again. When our firm hires a marketing firm, We say, these are our goals. These are the things that we want to come out of this marketing initiative. But we leave it to the marketing team to decide how to best accomplish those goals. They make the decision on how to do it, or we're making the decision on the ultimate goals and outcomes. So, as an employer of an independent contractor, you still have a little bit of control over the outcome. It's just you're not telling them, okay, to accomplish this, we're going to spend X amount of dollars on social media, and we want to hit Instagram, and we want to hit Facebook, and we want to hit LinkedIn, and we want those posts on these social media platforms to say X, Y, and Z, and we want them to pop up for these type of individuals. That's all stuff we leave to the marketing team. And that is what really makes it an independent contractor relationship. The second category is the financial aspect. So again, does the independent contractor have the ability to improve their profits and profitability of the business by making certain decisions? Or are they showing up and getting paid X amount of dollars for every hour, every day, every week that they're there? And then the third factor third category, these aren't factors, they're categories, is the type of relationship. And so something that's important to note is simply because you have an independent contractor agreement does not definitively mean you have an independent contractor relationship. But it is a factor, and it certainly can help with this analysis, because if you have it written down that all of these things are going to be the case with the relationship, as long as you're following that in practice, that is a key piece of evidence that will be used in these analyses. But the other types of relationships that would fall into this category are benefits, any non-competes, any non-solicits. If you are providing a worker benefits like health insurance, time off, paid time off, bereavement leave, they're almost definitively an employee. Those type of benefits do not go hand in hand with an independent contractor. So if you have independent contractors you're providing benefits to, you should very strongly reevaluate that decision. When I said non-competes, again, one of the hallmarks of an independent contractor relationship is that their productivity and their business decisions allow them to be more profitable. If they have a non-compete and they're only able to provide services to your company, they're probably an employee, regardless of what you've classified them as in the agreement, because they don't have that ability to go and work for another company performing similar services. Now, that's not always the case. If it's, for example, if you're an independent contractor with the labs, there may be a non-compete that you can't go and provide the same services to Lanel that you do for Sandia, just because they're in direct competition and there's some national security implications there. But generally speaking, independent contractors do not have non-competes. Next slide, please. So the National Labor Relations Board. So a really common misconception for employers is that the National Labor Relations Act does not apply to them unless they have union employees. That's not the case. The National Labor Relations Act applies to all employers because it says that employees have to be able to have the right to form unions, bargain collectively, and improve their working conditions. And to be able to accomplish that, they have to be able to engage in kind of a camaraderie amongst each other. So, for example, the NLRA says that employers cannot restrict whether or not employees can discuss wages with each other, because that could lead to them deciding to unionize. And so that is something that applies to all employers, not just unioned employers. So that is why there is a whole nother test for the National Labor Relations Board under the National Labor Relations Act. And this is a very totality of the circumstances analysis that is guided by common law factors. And when we say common law, these are just factors that have become part of the analysis through case law. There is not a set formula that the National Labor Relations Board uses. They just have a significant amount of factors, and these are kind of the big ones that they go through in that analysis. So again, you're going to see the same themes that we saw with the IRS, with the DOL. And so that first one is going to be the extent of control the employer exercises over the details of the work. So exactly like my example with the marketing firm. Are you telling them exactly how to accomplish something, or are you just telling them what outcome you want and letting them make the decision on how that comes about? The second, whether the work is usually done under the direction of employer or without supervision. So again, are you regularly checking in with this marketing firm? Are you having daily phone calls with them to say, I want to know exactly what you did today. How did you spend my money? That's going to lend itself more to an employment relationship. Whereas if you say, let's have a monthly check-in where you tell us broad strokes what you've done and the metrics to show that what you're doing is working, that's going to be more an independent contractor relationship. Third, whether the worker is engaged in a distinct occupation or business. So again, that's kind of that skill and initiative factor that we talked about under the Department of Labor analysis. So are they acting in a business capacity? Are they acting as their self-employer? 4 is how much skill is required in the particular occupation. Again, kind of back to that skill and initiative. Doctors have a very particular skill that they can use to leverage the market, where a lot of employees rely on their employer for training. So you work at a car dealership, you're going to rely a lot on your employer to train you how to sell cars, how to put the information in the system, what documents are going to need to be used to effectuate that car sale. All of that is going to be provided by your employer. Whereas if you're an independent contractor, you have that knowledge, you have that skill already when you come into the relationship. So that marketing firm, they're already skilled marketers. They already know what needs to be done to accomplish specific goals. 5, whether the employer supplies the tools and the place of work. So again, employers generally are providing their employees with all of the tools necessary to perform the work, as well as where they perform the work. The place of work has really become less of a definitive factor or even part of the analysis in recent years. After COVID, with everyone working remotely, that has become really something that isn't part of the analysis as much anymore, but it's still included here just as kind of an example. 6, the length of time for which the worker is employed. So again, indefinite time frames of work are generally more an employment relationship, where an independent contractor relationship has that definitive cutoff date, whether that is time-based, whether that's project-based. 7, the method of payment. So again, that ability to increase profits. If you are paying a worker a set amount for the hours they work, it doesn't matter if they get 3 things done in that 8-hour period, or if they get 20 things done in that 8-hour period, they're still getting paid the exact same amount because they worked 8 hours. And if that's the case, that's going to be more employee-based. And then finally, 8, whether the work is an integral part of or is part of the regular business of the employer. So again, that's that integral part factor. Are you hiring independent workers to perform the work that is necessary for your business? They may not be independent contractors. Next slide, please. So the EEOC also has its own test. Again, this is a totality of the circumstances analysis, and they have even more factors. So I'm not going to go through each one of these because we're pretty much just saying the same thing again. But what's important to look at here is there's 13 various factors that we're looking at for the EEOC, where for the NLRA there was 8, when there were 9. When we're talking about the IRS, there's 3 categories rather than factors. When we're talking about the Department of Labor, there's 6 factors. So in the EEOC, if you have 11 of the 13 that weigh in the favor of an independent contractor analysis, maybe that they do deem them an independent contractor. Where if you're in the Department of Labor and you have 4 of the 6 that lend themselves to an independent contractor, maybe they don't say that that is an independent contractor relationship because those 2 factors that lend more to an employment relationship are really significant factors, and they are so far on the sliding scale towards employee that they're not an independent contractor. So you can see that even though we're talking about very similar thought processes and analyses, they don't always result in the same outcome. And that's why this is such a complicated topic, and this is why it's so important to have this analysis done by a trusted professional who is really skilled in this area, because you don't want to be misclassifying employees as independent contractors. And we'll talk a little bit more about that in a minute. But it really can be overwhelming when you see all the various factors and all of the various tests by the various agencies. Next slide, please. So the New Mexico Department of Workforce Solutions and the New Mexico Human Rights Bureau has something called the ABC test, and this is actually from statute. I will say that this is part of their analysis, but it's not their only analysis. They rely a lot on the DOL's analysis as well when doing these types of determinations, but this is statute. So the ABC test says, well, and they call it the ABC test because it's A, B, and C subparts. So first, the individual has been and will continue to be free from all control or direction over the performance of the services, both under the individual's contract of service and in fact. So this is just important to point out that just because your independent contractor relation or agreement says one thing, if that's not what's actually happening in practice, it doesn't help you. It has to be true under both. So if your independent contractor agreement says that the worker is going to have the discretion to make their own schedule, but in practice, you're calling them up and saying, well, I know that you put in and said that you want to work noon to 7 every day, but I don't need you noon to 7. I need you 8 to 5. It doesn't help that it says in your contract they're going to have discretion over their schedule. B, the service is either outside the usual course of business for which the service is performed, or that such service is performed outside of all the places of business of the enterprise for which such services is performed. So again, are you providing services that are integral to the business? As a law firm, is the worker providing legal services, or is the worker providing plumbing or marketing services? those are ancillary. While they're still important to the operation of the business, they are not the core of what that business does. And C, the individual is customarily engaged in an independently established trade, occupation, profession, or business of the same nature that is involved in the contract for service. So this kind of looks at both the skill and initiative, as well as that independent, being in business for yourself, ability to increase profits or losses based on business decisions. Next slide, please, Mia. So there are other tests. We're not going to go into them here, but the New Mexico workers' compensation, has its own test. The New Mexico Construction Industries Licensing Division has their own test. So if you're in the construction industry, you should go and read those rules, because they are actually a lot clearer than most of these are. It's a lot easier to find that line in the construction industry. And then it's also important for you to understand that we've gone through New Mexico law here, as well as federal law. But if you have workers performing services outside of New Mexico, those states' analyses are going to apply to those workers. So, for example, you have remote workers that are in California and Texas. Those states' tests are going to apply to those workers. And so it's important for you to understand what those tests look like as well. Next slide, please. So predominant test factors. Again, while I said that there's so many different tests, we did kind of look at the same type of information that all of the tests are looking at. It's just how they phrase it and how they weight it. Now, in the law, if you guys have had experiences, you'll know that the one little word can change the interpretation of a clause. So while they all are looking at similar factors, one word can mean the difference between an independent contractor versus an employee. So it can be really overwhelming. I will say the two big tests that are universally used, or not universally, I don't want to say universally, but are generally used in these analysis are going to be the IRS 3 category test and the Department of Labor 6-factor test. But again, it's important to remember one size does not fit all. It's easy to mix things up. There is case law that is changing regularly. And then this is also where I will input a disclaimer. These agencies change their tests pretty regularly. The DOL had a new test at the beginning of last year. The National Labor Relations Board had a new test end of 2023. These agencies and divisions, as we've all seen with employment law in the last couple of months, really depend on who's in office and what political party has the majority in that agency, especially when we're talking about federal agencies. So it's important not to rely on this presentation to do your analysis, especially if you're watching this in the future. Oh, next slide, please. So key takeaways. The keys to these analyses are really whether the individual is economically dependent on the business or whether they're in business for themselves. So again, profits and losses. Are they investing into their own materials and equipment? Are they able to generate more profit, the more efficient or the more projects they take on, or the way they run their business? And then the level of control the company or the employer has over the worker on how they perform the work. Not what the outcome is, but how they perform the work. Are they dictating when they show up and do the work? Are they dictating the processes for how they do the work? Are they dictating the tools that are utilized for the work? Then I also want to go through some not relevant factors. So the company or the worker's classification. Again, just because you have an independent contractor agreement does not mean that that worker is an independent contractor. Some agencies will look at that as a factor. Some of them don't care at all. Like the Department of Workforce Solutions doesn't care if you have an independent contractor agreement. They care about the nature of the relationship. And I also caution you, because just because your independent contractor or your worker says they're an independent contractor and agrees with you right now, the majority of these issues arise when a worker has something catastrophic happen to them. They get injured on the job and they're classified as an independent contractor, so they aren't eligible for workers' comp. They get fired and they feel like they were discriminated against. Well, if they're an independent contractor, they don't have employment protections based on those immutable characteristics, and they can be discriminated against. So they feel like, well, I got fired because I am Black, or I'm a woman, or I'm Muslim, and I don't feel like that's right. So I'm going to claim that I'm actually an employee, even though I previously agreed I was an independent contractor. So just because your worker says and agrees with you right now doesn't mean they will in the future. Same with taxes. Just because they are in agreement right now, when taxes come due next year and they get a huge tax bill because you haven't been withholding any of the deductions from their wages and they can't afford it, all of a sudden they're going to claim they're an employee. And you should have been doing it. So the next non-relevant factor is whether or not you provide a 1099 or W-2. Again, these agencies don't really care what you've classified the worker as. They're going to do their own analysis. And then whether an employee is an individual or a corporation or a company in general. Individuals can be guilty of misclassifying workers. So you have a domestic worker that comes in and cleans your house, you could potentially misclassify them as an independent contractor depending on the relationship. Both individuals and companies can be liable for violations. The same is in reverse. So just because generally this comes into play when the worker is an individual and they haven't formed their own company, but the formation of their own company is not definitive as to whether or not it's an independent contractor versus employee. I have seen, it's unusual, but there are circumstances where a company can be deemed an employee because there's only one person working, and so they kind of ignore that corporate formality and then just deem the worker as an employee. So just because you're contracted with a company, if the rest of the relationship lends itself to an employee, doesn't protect you. Next slide, please. So consequences of the failure to classify correctly. So I kind of touched on this as we went along, but employees, you're required to withhold from their wages certain taxes. If you're not doing that because you've classified them as an independent contractor, you could be liable for those back taxes as the employer. Almost all of these acts have fines and penalties built into them for not following them. So for example, the Fair Labor Standards Act, if you are not paying a worker that you've deemed an independent contractor overtime, because independent contractors aren't subject to overtime rules, but you've misclassified them and they're actually employees, not only are you going to owe that money that should have been paid as overtime, but there's also going to be fines and there's going to be penalties assessed against you as well by the DOL. There could also be interest. Tax liens, that kind of goes back to the IRS and taxes, lawsuits. So employees are protected by anti-discrimination laws. Those are not generally applicable to independent contractors. But if you do discriminate for whatever reason and the worker files a complaint, you could be liable for some lawsuits there for discrimination, wrongful termination, etc. Liability for medical bills. So this is going to come into play with workers' comp. If they should have been covered under workers' comp because they were an employee and not an independent contractor, you could be paying out of pocket for all of those medical bills, or the business, not you as an individual. Liability for lost wages. Again, that's workers' comp, unemployment type issues. Vicarious liability. So this is a term that means that your employee's liability transfers to the business, the employer itself. That's not the case with independent contractors, but you certainly don't want to get into a situation where someone you've deemed an independent contractor does something and now all of a sudden you have vicarious liability. Next slide, please. So best practices. Nobody is ever going to question an employment classification. So if you're not sure, the safest, least risk adverse option or least risky option is to classify them as an employee. If you classify them as an independent contractor, just know that there are all of those risks that come with misclassification. The best thing you can do to mitigate the risk if you do want to deem somebody an independent contractor is get this analysis done by an attorney or a trusted advisor or someone who's familiar with all these rules. And just because you've done this analysis doesn't mean that you can't still be liable in the future. Courts and government agencies do things that surprise me all the time. So if you're on the line and you think, well, I think that this really is an independent contractor relationship, even though because I've done the analysis, if you're not confident, if you're not so far on the independent contractor side of the sliding scale, it's a risk to deem them as an independent contractor. Written agreement. Written agreements certainly help. They're not definitive, and you have to be abiding by them in practice as well as what they say in the contract. But they certainly help. Independent contractors' items to consider. Clarify scope of work, deadlines, and payment terms really clearly, because as you saw through this whole presentation, those are going to be key factors in determining whether a worker is an independent contractor. Memorialize the classification to avoid misunderstanding. Again, it's not definitive, but it certainly helps. Confirm work product ownership. So this is more not whether somebody is deemed an independent contractor, but it is something you should keep in mind. If, like that marketing firm example, if they're producing marketing materials for you, do you own them or does the marketing firm? Because if the marketing firm owns them, when you are no longer using their services, you may not be entitled to continue to use that product that they put together. So it is important to define that in your agreement, even though it won't help with the determination of classification. Protect with a confidentiality and or non-solicitation agreement. So we talked about how non-competes are pretty much non-existent with independent contractors. There are other ways to protect your business when working with independent contractors. So non-disclosure agreements, confidentiality, those are all heavily encouraged and really beneficial for employers. Non-solicitation agreements. So the difference between a non-solicitation and a non-compete is a non-solicitation still allows the worker to engage in similar business. They just can't solicit your customers that they learned of through the engagement, and they can't solicit your employees. Now, they can work with them if those employees or customers come to them independently, but they can't reach out and say, hey, Mia, I know you work for ABC company, and I really enjoyed working with you on this project. I'm starting my own company, or I work for this company, or I have my own business, and I think you'd be fantastic in this role. If you do that, I'll pay you 10% more. That would be a solicitation. Then finally, confirm disassociation process. So as we went through previously, independent contractors generally have a definitive termination date. So either when the project is complete or at a certain time period. And so what happens at that termination? What materials and documentation do they need to turn over to you? Where does liability cease? Who has what liability after the termination, et cetera, et cetera. Employee items to consider. Again, clarifying job duties and full-time, part-time, temporary. Those are all going to be important. And I highly encourage you to send offer letters to your employees, because that is generally the only form of written documentation that most employers have with their employees, because employment contracts are not as common for the general worker. They're more common with highly specialized employees like doctors, the CEO of the company, those kind of employees. And so clarifying those duties and specifics of the job with an offer letter is a great best practice. Clarify benefits. Again, if you're offering benefits, they're almost always going to be an employee, but you should clarify them, because if you promise something and then don't deliver, or you don't promise something and the employee claims that you did, that offer letter is going to be really important in that dispute. Compensation terms, for all of the reasons we just discussed. Again, you can have non-disclosure, non-compete, non-solicitations with employees. Just a caution on non-competes. They are still enforceable in New Mexico, but there has to be legitimate business purpose for them. And as you may know, there was an attempt to do away with those by the FTC this last year. It didn't move forward, but there is a trend and a push. I don't think it'll happen in the next 4 years, but it is something on the minds of a lot of people. It's really important to specify that your employees are at will. That's the default, but you never want to get into a circumstance where you have made certain promises and all of a sudden you've taken them out of that at will relationship, and you now have to do certain things, or you have to give them certain notice before you're able to terminate. And then confirm work product ownership. Again, it's a lot easier with employees, but it never hurts to clarify. Next slide, please. So when in doubt, consult with your trusted attorney or advisor. Classify as an employee, because no one's ever going to question that classification. And you can apply for classification confirmations with various agencies. The IRS is the one that this happens the most often with, where you submit a certain fact pattern to them and they will tell you, yes, this is an independent contractor, or no, this is an employee. Next slide. All right, questions. Me didn't stop me at all, so I don't know if you guys have any questions.
There's no open questions at this time, and if anybody has any, I invite you to put it in the Q&A. And all I can say is, wow, Taylor, that was a lot of good information. Wow. Yeah. And I thought I knew something about that, and now you've just blown my mind, but it's all good. It's all good. And this will be posted on the New Mexico State Bar website under MMH publications. We post all of our webinars up there, so this will be up there probably within the next week. Okay. Okay, so there's no questions at this time, and we're hitting the hour mark, so I think we will let you be free to have the rest of your day, and thank you so much for watching, participating, and stay tuned for the next installments next fiscal year. Thank you.